Hello, and welcome back to Topics and Decisions in Patent Law. I'm Joe Murphy.
I'm Reza Mollaaghababa.
I'm Reza Sadr.
In our last video, we took a look at the Patent Eligibility Restoration Act of 2023, which is a proposed piece of U.S. legislation aimed at addressing recent Supreme Court decisions that have narrowed the scope of patent-eligible subject matter. PARA, as the act is called, has been proposed to amend Section 101 of Title 35 of the U.S. Patent Act, which defines what kinds of inventions can be patented. In recent years, the Supreme Court, through cases like Mayo and Alice and Myriad and other cases which we'll be discussing today, has ruled that certain types of inventions, particularly in the areas of medical diagnosis, biotech, and software, are not patent eligible under Section 101. So in this video today, we're actually going to take a look at some of the important cases in this area and see if they might have been decided differently under the PARA framework. So just as a very brief refresher, let's take a look at a new slide with 35 U.S.C. 101. Currently, as it stands, 35 U.S.C. 101 reads, whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, any new and useful improvement thereof, may obtain a patent therefor, subject to the conditions and requirements of this title. That's fairly straightforward, but the way it's been interpreted by the courts, especially the Supreme Court recently, relatively recently, over the past decade or so, has added a new layer or an additional layer of what they call judicial exceptions to patent eligibility. So these are things like laws of nature, natural phenomenon, and abstract ideas. So claims that are directed to these, and we'll get into the analysis briefly, can be considered patent ineligible. If we look at the Alice Mayo framework, which has been used by the courts to determine what is and is not patent eligible, it's essentially a two-step analysis. You determine if the claim is directed to a judicial exception, as I mentioned, law of nature, abstract idea, or natural phenomenon. If yes, then we determine whether the claim includes additional inventive features that transform the exception into a patent eligible application. PARA's state of the law would be such that it would kind of remove this, look at the these judicial exceptions, and also hopefully remove the analysis about the state of the art and things like that. So I think, Reza, you wanted to take us through the proposed new law.
Yes, thank you, Joe. So I'm going to go over the proposed new law PARA in this slide very briefly because, as Joe said, it has been discussed in our previous video. Under PARA, we have a new section 101, as you can see here, and it has three subsections A, B, and C. Subsection A embeds the present statement of section 101 with some important differences. One is that wherever the law says new and useful today, it has removed the word new for an emphasis that PARA, one of its objects is to decontaminate section 101 from any indication related to other sections of the law related to novelty or non-obviousness. Another important distinction in subsection A is the addition at the end that it's subject only to the exclusions in subsection B. In some sense, sending a signal that other entities, in particular judiciary, should refrain from adding more exclusions. All exclusions are included in the statement of the law. Subsection B lists those exclusions. I'm not going to go into detail because we are going to go back to these when we analyze the cases. In summary, it just lists exclusions such as mathematical formula, mental processes, economic, financial, or business methods, and unmodified human genes or unmodified natural materials. For each of these exclusions, it includes important exceptions or qualifications. Subsection C relates to eligibility, when again, it's further emphasis on the fact that the claims should be considered as a whole and without regard to other aspects such as the state of the art or what is conventional, things that now have entered into the law and PARA is trying to get away from. So that's the law. Reza, I think we now go to you for analysis of a case.
Yes, thanks, Reza. As Joe mentioned, we thought it would be interesting to look at some of the seminal cases in the 101 area and see how they would fare under the new para proposed legislation. So one of the famous cases in the 101 area is the Diamond v. Deere case. And here the claims were related to a method of operating a rubber molding process. And the idea here was that one uses the Arrhenius equation to monitor the temperature and then open the press automatically when the correct temperature had been reached. So under the present case law, the Deere case, the Deere invention was deemed to be patent eligible because even though it used the Arrhenius equation, a mathematical formula, nonetheless, ultimately it was a process of operating a rubber molding press, and it involved not only using the equation but also opening the press when the mold was, I think the rubber was ready. If one were going to look at this under the new para proposed legislation, it seems to us that, of course, one would reach also the conclusion that it is patent eligible because such a method is not substantially economic, financial, business, social, cultural, or artistic, so it doesn't fall under those exclusions in the para legislation. And also, even though it uses the Arrhenius equation, so even though it has a mathematical formula embedded in the method, nonetheless, it is used in the context of an invention. And that's another point that para makes, that if the mathematical formula is used in a claimed invention that is presumably useful, which in this case it is, then the claim would still be patent eligible. So it seems to us that this famous case would probably end up the same way as being patent eligible under the para proposed legislation. So I think I turn it now to Joe, I believe, for discussion of Mayo case.
This is one of the standout cases in this area of the law. So we have the Mayo Collaborative Services versus Prometheus Labs, and the Supreme Court case, obviously. And the technology here was directed to a method for optimizing drug dosages by measuring metabolite levels in the blood after administering the drug and adjusting the dosage based on certain specific thresholds. You know, I've got the claim here up on the slide, so we just take a look, and we'll go through it real brief. I'm not going to read it. So we've got a method of optimizing therapeutic efficacy for treatment of immune-mediated gastrointestinal disorder. And here are the steps, right? We've got administering the drug, providing the 6-thioguanine to a subject with the condition. The only other step is B. We determine the level of 6-thioguanine. And we see that if the level of the drug is less than, and it's got a certain amount, indicates the need to increase the amount of the drug subsequently administered to the subject, or if the level of 6-thioguanine is greater than the cutoff level, 400 picomoles, indicates the need to decrease the amount of the drug subsequently administered to the subject. Now, in the Supreme Court decision, they ruled that this was patent ineligible because the claims were directed to a law of nature. That is, a correlation or relationship really between the metabolite levels and the drug efficacy and the toxicity. The additional steps of administering the drug, measuring the metabolite levels, and adjusting the dosage were deemed conventional and insufficient to transform the law of nature into a patent eligible application. So you see here already that creeping into the analysis is looking at the state of the art and whether, you know, they use the term conventional here. So if we take a look at para, you know, how might this case have been decided under para? Again, in para, as we mentioned, there's no judicial exceptions, right? So you take this law of nature or natural phenomenon and also abstract ideas or whatever as barriers to patent eligibility off the table. And so really the diagnostic method here likely wouldn't have been excluded from patent eligibility simply because it involves a natural correlation. that is between the metabolite levels and the drug effectiveness or toxicity. Instead, we focus on the statutory categories, right? So Para would ask whether the claimed invention is a process, machine, manufacture, or composition of matter. And here it's clearly a process, right? We've got this diagnostic method or therapeutic efficacy method. So I guess likely under Para, this case would have been found to be patent eligible. And again, it's a process, and as Reza had looked at in the previous case, it doesn't really fall within those other sort of process exclusions of social issues and business methods and artistic endeavors and things like that. So again, it's just simply, is it a process? Yes. And then we kind of move on from there for patent eligibility. So I think we'll go to the next case.
Yes, thank you, Joe. So you looked at Mayo. Let's look at Alice, the other seminal case of Supreme Court that gave its name to the new framework, Alice/Mayo. This was a 2014 Supreme Court case. Here, the invention and the claims, as stated by the opinion of the court written by Justice Thomas, the claims are directed to a computer-implemented scheme for mitigating settlement risk, the risk that only one party to a financial transaction will pay what it owes by using a third-party intermediary. What does that mean? On the right, you see one of the figures, the flow chart. Essentially, what is happening here is assume different parties during the day entering transactions, and while during the day their accounts by the financial entities not balanced, it could happen that some parties essentially spend more than they have in their account and go into the red, but that won't be revealed until the end of the day when the balancing occurs. Now, the solution here proposed by the invention and the claim is creation of these shadow accounts. How does that work? We go to the next slide. It's easier to describe it in light of the claims. And here is claim 33, which was analyzed by the Supreme Court. It's directed to a method of exchanging obligations as between parties, okay? That's what we were talking about. And what happens here is that this method creates shadow records, a shadow credit record and a shadow debit record. And as the transactions proceed during the day, these records are updated with every transaction. And if in any transaction, that's subsection paragraph C of the claim, if in any transaction the credit record exceeds the debit record, indicating that the party is going into the red, that transaction is prevented. And of course, at the end of the day, the balances are finalized and the accounts are balanced. So that's what the invention proposes to do. And what the Supreme Court did in this case, applied the framework that became the law, essentially said, although it's directed to one of the four categories, which is a method or process, at the same time, it is directed to one of the judicial exceptions. Here, maybe definitely an abstract idea, maybe the subcategory of a business method or a mathematical formula because of the subtractions and additions. And then it ended up saying the claim doesn't have anything more that is significant. It has using a computer doesn't help here because it's a conventional use of the computer, or all the other things are well known in the art. That's the Supreme Court's reasoning to reject the claim. Now the question is what happens under Para, hypothetically. Well, to begin with, like the previous two cases, one may say it is directed to one of the four categories. Maybe that's the end of the inquiry and saying that's it. There is no exclusion applied here. But if we go further and say, yes, there are some exclusions here, either under mathematical formula exclusion or under the subsection B1 capital B, it's substantial economic or financial or business method, then the next question is, okay, if it is excluded, does any of the exceptions to the exclusions apply here? For a mathematical formula, is it part of a claimed invention? In other words, is it more than just that mathematical formula? It may be a hard sell here. The other exception, if we apply the other exclusion, which is the economic and financial and business, the exception to it is whether this cannot practically be performed without the use of a machine or manufacturer, specifically here a computer. Again, that's a difficult argument to make because the transactions, the operations are so simple they can be performed with paper and pen or in the head of a user. One may think that if the claim had more meat to it, added elements that were like related to a large volume of transactions or calculations, or if it included some more complex mathematical operations, that may then save the claim under these exceptions. But I think the overall verdict could be most possibly this claim also would fail under PARA. All right, now back to you, Reza.
Yes, thanks so much. So the next case is Parker v. Fluke, which is also one of the seminal cases in this area. And as the slide shows, it relates to a method of updating value of an alarm limit in a process that includes catalytic chemical conversion of hydrocarbons. And as you see, there is a formula that the heart of the claim, and then that formula is used to adjust the alarm limit. In this case, the Supreme Court basically said that it's not patent eligible because essentially the argument was that the heart of the invention is this mathematical formula, and the remaining parts are simply so-called extra solution activity that are essentially very generic. And even though it is related to the use in a particular area, meaning the catalytic chemical conversion of hydrocarbons, that was not sufficient under the present precedent to save this claim from being patent ineligible. So the question, I guess, is what may happen under PARA? And under PARA, my understanding is that one should not really go and try to see what the gist or the heart of the invention is. One needs to look at this, whether it's sort of within one of the statutory categories, and it is in it's a method claim. And then the next question is, are there any of the exclusions that could apply? Well, it does have a mathematical formula in it. However, one could argue that the mathematical formula here is in the context of a useful invention, meaning adjusting the alarm limit for a particular process. The other question is that is this potentially would come under the exclusion that it is a mental process? Perhaps not, because even though one can perhaps mentally calculate the alarm limit, it still has the recitation of adjusting the alarm limit. And it is also in the context of a particular process of conversion of hydrocarbons. So it appears to us that in this case, this would perhaps be deemed as patent eligible under PARA, even though it was deemed as patent ineligible under the present case law. So the next case, I think, Joe, you're talking about the Myriad case.
Yeah, this is the Myriad case. And so this is Association for Molecular Pathology v. Myriad Genetics. And this is interesting because it's we get out of the method claims and now we're into product claims or composition of matter type claims. And here, Myriad Genetics had patents on isolated DNA sequences corresponding to the BRCA1 and BRCA2 genes, which are associated with increased breast and ovarian cancer risk. So I've got the two of the claims at issue here on the slide. We can take a look at them. So the first one is for an isolated DNA coding for the BRCA1 polypeptide. It's a polypeptide having the amino acid sequence of what's in seq ID number 2. Now that reads on the genomic DNA. That's the DNA that's actually in the body as part of the genome. And then in comparison, we've got claim 2, right? The isolated DNA of claim 1, where instead DNA has the nucleotide sequence as set forth in seq ID number 1. Now, this is a cDNA claim that reads on the cDNA. So the Supreme Court's decision under current 35 U.S.C. 101 was that the isolated DNA of claim 1, again, that reads on genomic DNA, was patent ineligible because it was directed to a product of nature. In comparison, claim 2, the cDNA claim, was found to be patent eligible because it is not naturally occurring and is a product of, quote, human ingenuity. So the way cDNA is made is basically take an mRNA. So the genomic DNA codes for the gene, it gets transcribed into mRNA, and then that gets sort of the introns get sliced out of it, and then there's a viral protein called reverse transcriptase that gets used to make this complementary DNA strand. And so therefore, that's not the cDNA is not something that would appear naturally in a human body, say, or in nature, really. So the way it's written, it's isolated. It's this complementary DNA. It's not natural. So therefore, this claim did pass the patent eligibility test. Now, how would this have been decided under PARA if that comes to be the new law? So again, PARA explicitly had removed the judicial exceptions, including the product of nature doctrine, from the patent eligibility determination. We basically look at the statutory categories as composition of matter, clearly, so it would meet that requirement. The isolated DNA sequences corresponding to BRCA1 and BRCA2 might not be excluded from patent eligibility simply because they are derived from nature. There is an exclusion in PARA for an unmodified human gene, as that gene exists in the human body. But again, here we get into the issue of this claim says isolated, claim 1, specifically claim 1, genomic DNA claim, says isolated. So theoretically, it may not read on that gene as it exists in the human body. So it's interesting to think what level of isolated is necessary, or the statute uses the term unmodified. How modified does it have to be to meet the statutory requirements? So this claim, I think, could be argued either way, but claim 2 clearly would still meet the statutory requirements under PARA as it did under 35 U.S.C. 101. So I think next we want to take a look at, Reza, you want to take a look at the Bilski case?
Yes, thanks, Joe. So Bilski case is, again, one of the important cases in this area. And Bilski's method has to do with managing risks in commodity trading. And I won't go necessarily through all the steps, but it is essentially a method of hedging risks in commodity trading. And under the present law, it was deemed as being essentially abstract and not patent eligible. So the question then is, what would happen if one were to analyze this under the proposed PARA legislation? First of all, of course, it is relates to one of the statutory categories. It's a method, it's a process, but there is a potential exclusion here that could apply. This could be deemed as being a substantially business method or related to performing a business transaction, and as such could be potentially excluded under PARA as well. Of course, there is this, as Reza mentioned, there is this exception to exception, I guess, that even though even a business method claim could be patent eligible if it could only be practically performed by a machine, such as a computer. Now here, the way this claim is written, one could argue that this doesn't necessarily need a computer to be performed. And even if one looks at the next slide, which is a couple of the dependent claims, and in particular claim 4 that has a very specific mathematical formula for performing the method. Again, the way it's written, the mathematical formula, one can argue that doesn't necessarily require the use of a computer to be able to practically perform it. As Reza mentioned, maybe if one had in such a claim something more, for example, the number of these transactions that are performed in a given time period, that would then could not be done, practically could not be done without use of a computer. Maybe you could save it. But I think as the claims were written, even under PARA, the chances are that such a claim would have been deemed as patent ineligible. And I think I'm now turning it to Reza to talk about another case.
Yes, thank you, Reza. So now we are looking at the DDR case. This is a Federal Circuit 2014 case. One general note here, what we are doing, we are looking at different cases, some of which were allowed and deemed patent eligible and some patent ineligible. The idea is to double check the assumption of whether PARA, as it claims and aims, is it more permissive than the existing law? In other words, does every case that was deemed eligible under the existing law, will it come out still eligible under PARA? And will it still even allow some of the rejected ones now to be allowed? And DDR is a case in which the Federal Circuit deemed it to be patent eligible. So what is the invention? As the court characterized it, it's directed to a system and method for generating a composite web page that combines the visual elements of a host website with content from a third-party merchant. What does that mean? Imagine a scenario like websites such as Kayak or Travelocity website. And the user goes there to find, for example, an air ticket from one of the airlines. And it does a search, and the website, the so-called host website, presents to it some options. And normally, if the user clicks on one of the options to explore further, the user goes to a new website, and after done whatever they want to do, if they want to go back, they have to click back. Maybe it's cumbersome. Maybe they lose track of the original host website. And what this invention aims to do is resolve or solve this problem by creating this composite web page. What does that mean? Let's look at the claim. It's easier to explain there. So essentially, it's directed to an e-commerce outsourcing system, and it first stores the look and feel description of the host web page, and then it generates that composite web page, which essentially what it does is when the visitor clicks on one of those links, it doesn't go to the new web page of the vendor, but it shows this composite web page in which you still have the look and feel of the host, like the Kayak or Travelocity, and within it you have the information you need from the airline. And it makes it such that the user, first of all, is all aware that they're still under the host web page, and then easily can go back to it to explore the other search results. That's what the invention does, as stated in this claim. And the Federal Circuit here deemed this claim to be eligible, and the argument here was, specifically in the wording of the opinion of the court, it solves a problem faced by websites on the internet. This is one of the first appearances of the wording of that the exception here, the judicial exception, which one may say is the e-commerce thing, is the commercial business method, solves a technological problem or has a practical application, or what later sometimes was worded as it is a technological solution to a technological problem. This case was important because after the new regime, the new framework came into existence, one of the areas that fared worst and was harmed seriously was the software inventions. And many of them were rejected under the new framework, and they all seemed to be, it seemed to be a lost cause until cases like these came out and opened some window and showed some green light. How does this fare under PARA? Well, to begin with, it is directed to one of the four categories of eligibility, which is, in this case, for this claim is a system. Maybe that's the end of the inquiry, and then we go on. We go to other subsections of sections of the law, like 102, 103, so on and so forth. But if one insists that no, one of the exclusions applies here, maybe the exclusion is a mathematical formula because of creating a web page, then does the exception to the exclusion, which is it part of a claimed invention as is marked in green? One can argue that it is, because it is like an application of this so-called mathematical formula in a real invention, which is a system here, whatever it does. It's noteworthy here to say, as we said, we are trying to figure out whether PARA is more permissive, which means, does it include all the green lights that exist in the existing law and more? And one of those green lights that I mentioned was that application of the judicial exception in a practical use. And it's that green light is not explicitly worded in PARA, but one area or one place that it may essentially be into play is what I just mentioned. Maybe that wording of being part of a claimed invention, one of the versions of it, or one of the appearances of it, is exactly when there is a practical application of the judicial exception. Okay, now if one looks at another exclusion, which is method that is economic, financial, or business, one may say that applies here if one does. But important point is that the exception to that exclusion also applies here, which is this claim cannot practically be performed without the use of a machine or manufacturer, specifically a computer. Definitely creating a web page and using it is all in the context of a computer and cannot happen outside that realm. So most probably under PARA, this claim will still be patent eligible. Okay, now back to you, Joe.
Thanks so much, Reza. Appreciate it. This case is another Federal Circuit case, Arias Diagnostics v. Sequinom. So the technology at issue in this case is a non-invasive prenatal diagnostic testing method, which had been developed by Sequinom. So this method used cell-free fetal DNA, which is present in a pregnant person's blood, to determine genetic tests of the fetus. So let's explain that a little bit. So Sequinom had discovered that the cell-free fetal DNA, which is fetal DNA circulating in the mother's blood plasma, could be reliably detected and used for prenatal testing. And then, this is significant, or was a significant breakthrough, because it eliminated the need for invasive methods like amniocentesis, which carry some risk. So if we take a look at the claims, and again, we're back to a method claim, right? So we've got a method for detecting the paternally inherited nucleic acid of fetal origin. So we're going to detect paternal DNA, and it's going to be performed on maternal serum or plasma sample from the pregnant person. And then the method further comprises amplifying the paternally inherited nucleic acid from the serum or plasma sample and detecting the presence of a paternally inherited nucleic acid of fetal origin in the sample. So that's something like PCR, things like that. So the decision by the CAFC was that this technology was not patent eligible. These claims were not patent eligible, I should say, under 101, because it was directed to a natural phenomenon. So that is the existence of this cell-free fetal DNA in the maternal blood, and then it did not contain an event of concept sufficient to transform this natural phenomenon into a patent eligible invention, specifically because the method applied well-known laboratory techniques like PCR to detect the cell-free fetal DNA, which the court considered conventional and routine. So the court emphasized that merely discovering and applying natural phenomenon does not meet the criteria for patent eligibility. And again, we see the prior art type or state of the art, I should say, type analysis entering into here. Does the process use something that's unconventional as opposed to merely using conventional things, even though you've newly discovered this natural phenomenon and made this useful method using it. So how might this have been decided under the PARA Act? Well, under PARA, as we've mentioned, right, there's no judicial exceptions. So this, law of nature, natural phenomenon, abstract ideas, like those are out. So those are explicitly eliminated. So the existence of the cell-free fetal DNA in the maternal blood, this new natural phenomenon would not necessarily render the claim method patent ineligible. Again, under PARA, we would focus on whether it falls into a statutory category, that is a process, machine, manufacture, or composition of matter. Clearly, this is a process, right? It's a method of diagnosis. It doesn't fall within the heightened scrutiny of the other processes that are specifically called out, that is, economic, financial, business, social, cultural, or artistic. And so, with that in mind, it seems like this method would have been found patent eligible under PARA. That said, of course, as Rez has mentioned, it would then go on to the rest of the analyses under, 102 for anticipation, 103 for obviousness, and then would have to meet all the 112 requirements as far as written description and enablement, et cetera. So I think we've got, Reza, you've got one more case. You got another case for us?
Yeah, and this is the last case I'm going to discuss, and this is the so-called Hulu case. And as you see, it's a method of monetizing copyrighted products. And under the present case law, even though it's essentially a method of doing business, it was deemed as patent eligible because it cannot practically be done without the use of a computer. In fact, the use of multiple computers that are interconnected via network. And the question then is, under PARA, how would it fare? And well, first of all, it's a method claim, so it's one of the statutory categories. It can be viewed as a method that is substantially economic, and so therefore it could fall under the exclusion, but it could be saved from that by essentially the same analysis that the present court used. Is the idea that it cannot be performed as a practical matter. It cannot be performed without the use of computers. In fact, the computers and the interconnectivity is really extremely important for this claim. Otherwise, it wouldn't be able to do what it purports to do. So we feel like the chances are that under PARA also it would be deemed as patent eligible. And now I'll turn it to Reza for, I think, one last case.
Yes, thank you, Reza. So this is the last case we are considering today, the case of Mobile Acuity versus Blipper. It's a more recent 2024 Federal Circuit case, in which the claims were deemed ineligible, and we're going to see that under PARA, it's very possible to pass muster and be deemed eligible. So another case that we want to see if PARA is actually more permissive than the existing law. Here, the technology is directed to methods and devices relating to, as was formulated by the court, relating to storing information so that it can be accessed using a captured image. What does that mean? Assume in a scenario there is a person like a traveler going to a historical place, takes a picture and sends it to a server, but that photo with it includes some additional information. Maybe, for example, specifics to the person, what time they were there, with whom they were there, or maybe information about the place, historical, others. The server saves that additional information with the image and uses the image like a barcode, like an identifier for the information. And what's the point of it? We can go to the method here as part of the invention. What happens here is that if later a user goes to the same place and captures another image of the same area and sends it to the server receives that image and uses techniques to extract interest points from the image and essentially digitize it and turn it into information that can then compare with the images it has previously stored and identify the original image. Remembering that the new image may not be identical to the previous one. They just have some characteristics in common. That's the job of the server, to identify the old image and thus retrieve the information which was saved with it and send it back to the user. So I assume the same person goes to the same area and wants to remember, when was I here first? Or a different user goes there and want to know if somebody else has said anything about that area that is of interest. And that's what the claim does. Now, the Federal Circuit rejected the claim as ineligible by stating that it is directed to an abstract idea. What was it? The abstract idea is the process of receiving information, associating it with images, comparing images, and presenting information based on that comparison. You know, to me, this is an example of how subjective, and I may say wishy-washy, is application of the law. Here, every element of the claim is deemed as abstract idea. Now, one person's abstract idea may be another person's concrete idea, because these are very specific. But nevertheless, that was the judgment of the court. And then the court continued by saying that there's nothing more to the claim. It just uses generic computer components, and whatever it uses are existing conventional technologies, which is the wording of the law as it stands. Under PERA, we think, as I said, this may pass in a hypothetical application of PERA by an agent, a player like the Patent Office or a court. How? To begin with, we can say this is directed to one of the four categories. It's a method claim, and maybe that's the end of the inquiry, as we have said before. Or if we go further and somebody says, no, this is directed to an economic or financial or social process, then most probably the exception to that exclusion applies, because this cannot be performed without the use of a computer. This whole process of digitizing the image, identifying its elements, and then comparing with the new image, they all live in a computer and nowhere else. So this claim most probably will be deemed eligible, as I mentioned at the beginning. So I guess we get to the end of analyzing the cases. Maybe we want to have a quick discussion about these.
Yeah, I think I guess my overall thoughts on the PERA Act, I'm cautiously optimistic and I'm cautiously positive on it. I think it would be helpful. It would certainly be helpful for diagnostic method claims. Would be tremendously helpful, because those are, those can be difficult to get. I mean, there's ways around it. You can get, as long as you include a novel reagent or something in the claim, that can be a hook, that's not natural and things like that. But these correlation issues come up quite often. And just to say, well, it's a natural phenomenon, even though, it took us till, today to discover it. I mean, I understand that it's a natural phenomenon, but now you've put it into a useful method. And I think that would be really helpful. I think one counter argument might be that it would cast the net too broadly, although I'm a little less concerned about that, because of looking at, we went through Myriad, those two claims there. The cDNA claim was fine. It was fine under conventional 101 or current 101. Even under PERA would be fine. But now looking at the claim one, where it's directed to genomic DNA, I'm not sure that you should be able to get a patent on genomic DNA. Even now, it says isolated, but What if someone else comes up with a couple of, PCR primers that amplify a certain section of that genomic DNA and do something important with it? Are they going to be blocked out from doing that? And I think that's not clear yet. The statute says it's got to, it's got to be modified basically. It can't be natural unmodified section of DNA. I'm not sure how modified is modified. That kind of thing. Is isolated enough? I'm not sure. Does that mean you can use it for, some other method? Could some other company or laboratory come up with another diagnostic method? It's unclear. But that said, I think overall it's largely helpful.
Yeah, I mean, I think one of the things that I like about it is that this whole analysis of what is the heart of the invention, and then zooming in on that and saying, well, that's just an abstract idea, and then dismissing the rest as being potentially conventional, which is again goes to the question of what is conventional, what is not, which is really should be more in the domain of 102 and 103. Looks like Pera is getting away from that, and I think to some degree, to me at least, that seems helpful because it removes that subjective analysis of, first of all, what is the heart of the invention, and then, whether or not anything else is conventional, and the analysis becomes a little bit more mainstream. So I'm also cautiously optimistic if it actually gets enacted.
Yeah, actually, that's very important. Yeah, I want to emphasize at least 2 points related to the exercise we went through right now. And you both alluded to it in some sense. One is that this was just a very hypothetical exercise over the cases. Our understanding of para and assuming it will stay the way it is. First of all, let's remember it has to go through a process if it's passed, and even if it's passed, whether there are going to be modifications to it, most probably. It's very probable, remembering that there are other players here that want to push the other way against the permissiveness that we are identifying. Plus, it very much depends on the way it is interpreted. We said again, this seems to be one way to interpret it and apply it to a case. The other point I want to mention is that in some of these cases or others, when we apply para, it may seem that para is too permissive. This claim is so open, or it's so broad. For example, it's very preemptive, so we think this shouldn't pass, and this para is now going too far. Let's remember, as para itself says, this is just applying the 101. This is just the gate. This is just a threshold that the claim should pass. And the threshold used to be and should be rather wide. That's when the claim goes under the scrutiny of other sections of the law, 102, 103, and 112. And many of the reasons that come to our mind that the claim shouldn't be allowed actually fall under those sections, not 101. And that's what para emphasizes. Of course, we go back to the problem that brought in the new framework, and that is the high cost of applying the rigorous framework of 102, 103, or others. But maybe that's the price to be paid to go away from the terrible situation we are now in, at least in mind of some practitioners with applying 101.
Yeah, I had additional thought based on what you just said, Reza, about casting that too broadly and allowing too many things to be considered patentable subject matter, and then having to go through the further scrutiny under 102, 103, and 112. For these process claims, I think it's interesting how this para law is structured. The process claims get an additional level of scrutiny, right? Because there's this other situation where if it's a process claim, we have this other analysis of whether it's economic, financial, business, social, cultural, or artistic. So I think it's interesting that the drafters of this added those elements to this to try to get it out of the concept of, dance routines becoming subject to utility patents, things like that. Now, Michael Jackson had a patent but it was a device, a device used in a certain kind of dance. It wasn't the actual dance itself. So, if it's an artistic or social or cultural type of thing, there's a quick way out of hey, this isn't patentable. So I think that's a way to try to trim the sails a little bit on how much coverage is going to be allowable as patent eligible subject matter under para, but not make it too broad. So I think it starts to draw or starts to have a nice balance.
I agree. I very much agree. Essentially, para is trying not to absolutely or completely eliminate the existing judicial exceptions, but rein them in by bringing them in explicitly under the statement of the law, under the text of the law, and calling them exclusions. Some of the categories you mentioned are presently under judicial exception, but set boundaries for those exclusions and make it, as I said, more practical.
Great. Well, thanks so much. It's a great discussion, and these are some really interesting cases. And we'll leave it there. And everybody, have a great day.
You too.
Thank you.
Bye, Joe. Bye, Reza.